We apparently, we, we had a document that was uploaded onto the forums, apparently. They're not available on your e-platform where you go in, and you pull up everything. We apparently had an attempt to remove some public access to specific records. You can see it here. Dear Judge, whatever. The correspondence is submitted pursuant to, they give the pursuant Minnesota R Civil P. They give all the, blah, 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 blah. The latter rule permits the court to, upon motion and hearing, issue an order prohibiting public access to specific records. It's not, the way this was talked about, at first, when I heard about this, people were saying, oh, it's for every record. No, they're talking about access to juvenile protection case records that are otherwise accessible to the public only upon a finding that an exceptional circumstance exists. The former rules encouraging movements to attempt informal resolution of a non-dispositive motion, so they go through the motion on there, again trying to limit records that would pop into the public. This correspondent, the father is invoking Rule 1 of 5's enjoined to informally resolve his forthcoming motion for protective order pursuant to, again, gives the rule in there. Father, through counsel, will contact the appropriate court, administrative judicial staff to schedule a phone conference. Again, they're giving the different pursuant tos. The verse will be fully explained in its forthcoming motion and during telephone conference that exceptional circumstances required do exist. Counsel for father confirmed with the assistant, man, I always mess up the county attorney this morning, who indicated that she did not believe the county would object to a motion for a protective order. Respectfully. So, they give all their information. There's 3 pages, so including a denial. Give me 1 minute. Yeah, the correspondence is submitted pursuant to instructions from the court administration and as the request made. Correspondence on June 20th, 2024. Father herein requests that the conference call be scheduled as soon as possible. So you can see with the requests, having that or that. And guess how this goes. I wonder how it'll go. Let's find out. So, as far as this, the request is denied. So, as far as the limitation off of this, again, I'll go back to the post there. But as far as it, you can see the judicial response here, request denied, and other. Let's see what it says, and then we'll go back to the post. Pursuant to Rule 301, the rules of child protection, the civil rules of procedure do not apply. The court believes Mr. Wright is referring to a different item, which is rules for motion practice under Minnesota's general rules of practice. However, this motion here does not apply to juvenile protection matters. So I guess you quoted the wrong statute there. Whoops. Whoopsie. Request was denied with an interesting little notation here. Check this out. So, pursuant to 301 of the rules, child protection, the civil rules of procedure do not apply. So as far as what they noted there, as far as their statutes, they're like, the things that you noted don't actually apply to this. We think you're referring to this other thing that might actually apply, but as far as what you're referring to, I don't think you got that right there. So the court believes that Mr. White may be referring to, so R General P 115, which is the rule for motion practice under Minnesota's general rules of practice. However, they give another provision here. They say, well, this, the rules 3 through, and they give all of that there. The general rules of practice for district courts do not apply to juvenile protective matters. So they don't apply in this case. As far as what you were asking for and what you were saying, well, this allows you to do that. Yeah, we can't really do that because it doesn't apply. So pursuant to, our juvenile protective 8.07, Division 1, the court, upon motion and hearing, may issue an order prohibiting public access to juvenile protected case records that are otherwise accessible to the public. As far as kids are concerned, the public wants to know everything. Items that relate to kids, they don't pertain to Nick. They don't pertain to his wife or anybody else. The rules are there to protect them. Kids, they do deserve protections from this because this stuff will follow them. It will follow them forever. So you can understand why, there are rules that would allow certain records not to be out there. However, in this document, it looks like the judge is saying, hey, the argument you made doesn't really apply to this because those items, they don't apply to juvenile protection matters. Based on information provided this court, they will not issue the order. They will require a motion and a hearing. Now, if the attorney wants to request sort of from the assigned judge, they can file a separate request. So they tell them, at this time, no. You're not going to get that. And again, the reason for it, I'm like, well, that didn't go your way. Okay. Now, we also had more interesting. We had 2 different items that came up. The state dropped something with a note on it. And people were like, wait, what is that now? Well, what exactly is this? Yeah, all right, here we are. So, here's another document that was uploaded as well. In the matter of welfare of children with initial or supplemental disclosure, so they're talking about disclosure on this, to all parties, you're hereby notified. The name and addresses of additional prospective witnesses for the state are contained, if any, in the report attached to this notice. Police officers use departmental addresses, hospital, business, So they're telling you, it could contain addresses, the relevant additional written or recorded statements, if any, and the substance of any additional oral statements may be made by a party or participants here too, if any, are attached to the notice. At trial, the state may offer other additional items of physical evidence described in the attachment to the notice. The state may also offer additional diagrams, maps of crimes, arrests, etc. So they're telling them, these can be included in here. I'm just reading it off again, just through the whole freaking document. Additional results or reports of physical or mental health, our mental examination, scientific tests, experiments, comparisons are attached here too, except that if preliminary tests are only indicated, final tests will be disclosed prior to trial. So, they're going through there, this was brought up. Now, there was actually a response to this uploaded by, what's his name, Josh Moon. Because if you look at this, it goes through, again, no check marks. Child protection intake summary dated. And the dates, notice these dates here, 2209. Well, before what we've been talking about with this case. 0215, 2023. 0516, 2024. 0523, 2024. The 24th, 31st, and June 3rd. But there was a lot of, everybody ranging from Mr. Medicare on was like, what? Wait, what? Child protective intake summaries from 2009? What's going on with that? So, since you all are retarded and don't have a way to know, the 2009 case is not ours. We were foster parents for that placement. We had to stop fostering due to pregnancy complications with our second child. All CPS cases prior to our arrest date of 5/23 which is only 2, were screened out as not sufficient and ignored because there was no actual basis for them. So, again, this is his statement on it. When you look at that, I mean, there's a lot of dates. So, clarification, yeah. Anything, like if it were to do with me, you know, if it were me out here, for example, I wouldn't care as much. But if it dealt with my kids, I would want to clarify something. I kind of wouldn't want to give, you know, I wouldn't give a fuck whether somebody was telling me to shut up or not, because Bricada hasn't followed those orders. He hasn't been quiet about everything, so I would probably clarify that stuff. And I would clarify it in a... I wouldn't be vague at all. I would clarify it very, very well, especially considering everything else that's come up. You know, he said again before, he said, oh, I don't owe anybody any type of explanation whatsoever. That's true. You don't owe anybody. But at the end of the day, you know, the thing that will burn you down, it won't be getting busted. It won't be allegations of the nanny, you know, the stuff with Aaron and April. The thing that'll burn you down is kid stuff. So anytime that comes up, it's about a personal image too. You know, I wouldn't want anything like that attached to my kids. Like, forget about me. I wouldn't want that attached to my kids. If I thought there was some bullshit out there about my kids, I would want to clarify that. And I could understand if there was never any statement whatsoever about the case, but there's been a lot of statements about cases. So, yeah, you know, people, if they want clarification, ask those questions. You can see other things that are checked in here. Letters, requesting medical records, KCHHS, case transition forms, they were included in that. But the thing, you know, medical records. Yeah, you know, like people have said, that CPS called on you. Yeah, for sure. You know, I've had CPS called to my house because crazy people will do that. It's their first go-to. And you know what? If that when that happens, you know, I blast that shit too. And, you know, I would understand not talking about a case as well if that had been the go-to. You have to be careful with CPS. CPS is a very powerful organization. CPS, they can do more than anyone else involved in this. You will lose your kids forever this way. You're more likely to lose your kids than to lose your freedom with all of the stuff that's going on. You know, I've worked with kids in therapy, in mental health practice. People are less likely to do jail time than they are really, again, for CPS to make a ruling and to say that you're a danger to your kids. You know, again, oh, you did what? You invited who into your home? You were doing this stuff? You got arrested for drugs? That by itself could make you a laugh track. But the laughter will subside over time. It's the elements with children that become something that they don't shake and you don't shake. So, also included police reports, court documentation, testing. They noted children, segmented hair tests. So as far as this is concerned, they're talking about the hair follicle tests that we saw mentioned in the documentation, the last documentation that ended up coming up.